Non-Litigation and Arbitration Practice Group on the 2nd of January 2004 as an associate and was elevated as a partner of the firm in October 2006. He was subsequently made the co-deputy managing partner in July 2012. He sat on the firm's governance committee. Yang Mulia Dato' had climbed the ladder quite fast. He advises and acts as advocates and solicitor in a broad field of civil dispute resolution, among other, encompassing administrative and constitutional, automotive, banking and bank guarantee, company law, construction and engineering, e-commerce, energy and utilities, healthcare, infrastructure, joint venture, media and entertainment, negligence, regulatory and shareholder dispute, and many others. Yang Mulia Dato' had appeared in a wide range of forums, from the Federal Court, the Court of Appeal, the High Court, to arbitration. He also specializes in the preservation and recovery of movable and immovable property and information through interim and final injunction, freezing order, search order, delivery, and tracing. His greatest success was overturning an award of damages for breach of contract which exceeded billions of ringgit. In that case, he succeeded in the Court of Appeal and prevailed again in the Federal Court. The case involved complex points of law relating to civil procedure. Yang Mulia Dato' has in recent years been instructed to assist a foreign corporation in recovering specific financial and distribution documentation against its local distributor through an entente order, managing, negotiating, and restructuring multi-million ringgit debts and judgment owed by client to third parties on favorable terms, and preventing, by way of an urgent Marefa injunction, a foreign-owned corporation from taking high-tech data and computer components overseas. He has also been instructed to handle sensitive matters concerning issues in the national interest and official secret matters. Yang Mulia Dato' couldn't imagine himself being anything other than a litigator. In his career, the management and pursuit of victory in complex commercial dispute is his priority, and he enjoys sharing his experience with others to help them to do the same. Yang Mulia Dato' has many reported judgments accredited to his name. Yang Mulia Dato', for Yang Mulia Dato' information, most of the audience in this webinar are the final year law students. They are so eager to leave the university and to venture to legal practice. I'm sure our audience are excited as I am and can't wait to listen to Yang Mulia Dato' sharing. Well, audience, are you up for it? If you are, it is my great pleasure to present to you our speaker, Yang Mulia Raja Dato' Ahmad Mohzanuddin Shah Raja Mohzan. Yang Mulia Raja Dato', the floor is yours.
Thank you, Cik Yunus. Assalamualaikum warahmatullahi and good afternoon. It's great to be virtually back to the law school. I mean the law faculty. After so many years. Thank you to the law faculty for this opportunity. But before that, I have to, I must say that Encik Yunus taught me civil procedure. So that is the most single knowledge that I am still using until now on a daily basis. So thank you, Encik Yunus.
Thank you. You are welcome.
And congratulations on the appointment as a fellow of Kerusi Institute Raja Raja Melayu.
Thank you, Dato'.
Okay. Okay. Actually, the idea was first mooted when I met Dr. Sherry about 3 years ago. I was telling Dr. Sherry that I wanted to share whatever tiny, minor, limited knowledge that I have with the law students, most probably the final law students. But then time passed by, I got so busy. Then I think in January or February during Harun Mahmud Hashim National Client Competition, I had the opportunity of meeting with Associate Professor Dr. Hatini, and we discussed matter. And this idea came back to light, and we share the common interest of empowering the students. So the idea was for me to go to UiTM, but unfortunately, since we are in the COVID era now, so we have to do things by way of webinar. And you guys have to bear with me because this is the second time that I'm conducting talk through a webinar. The first time was that I was trying to focus myself because it seems that I was talking to myself alone in front of the computer, you know, because my idea of giving talk is that, you know, you have a rostrum, you can walk to the slide, you can walk down the stage, you can sit with the audience just to get the mood of it. But fortunate enough, we have this thing called webinar where we can still have our sharing session. So let's hope that something is achieved at the end of this seminar. Well, I cannot say that I am the best lawyer. I am not even a top 100 lawyers in Malaysia. There are 20,120 lawyers in Malaysia, registered with the Malaysian Bar, 20,120. But I can safely say that I am top 10,000 lawyers, I think, in Malaysia. So based on what I'm gonna share with you, since I am top 10,000 lawyers, so you can believe 50% and you can, you know, put aside the 50% of what I'm gonna talk. But regardless, I am so passionate to share whatever knowledge that I have with the audience, particularly the final year students. And I hope that at the end of this seminar, 3 things can be achieved. Number one, it will somehow motivate the students. Number 2, it will strike up friendships along the way. And number 3, most importantly, the student will be able to make an informed decision when commencing their population. Okay, I have to pause here for a moment because most of the times, Chamberlain students would come and see me and ask me this particular question. Can I do litigation for 3 months, conveyancing for 3 months, and corporate for 3 months? The answer is yes. You can do that in AZMI and Associate. But you cannot do that in my practice group. Because for me, you have to make up your mind whether you want to do corporate, you want to do conveyancing, or you want to do civil litigation. Because 9 months is not enough. And mostly, I promise my Chamberlain students that at the end of the 9 months period, they will acquire the knowledge of a 2 years experience associate. So because of that, to me, it is important for you to be able to make up your mind what you want to do. Of course, there is no wrong for you to try every aspect available. Because when I graduated that time, what I had in mind was only 2 things. Either I'm going to court or I'm going to do litigation work. Okay, if we can move on to the next slide. So allow me to talk a bit about myself. Sorry, about the firm, which has given me so much, I think, throughout the years. I have been with the firm for 16 years, and I am, for the moment, still here, just for the simple reason that my senior partner, Dato' Azmi, has been nice to me. Sometimes I was hoping that he wouldn't be that nice, so that at least I can jump ship to somewhere else. But so far, I am still here, and probably limitation has expired. If you look at the slide, currently we were established in September 2000, and we have 172 lawyers. And what unique about our firm is that we have one qualified foreign lawyer, qualified in Malaysia, qualified in the UK, and in France. We are the only law firm in Malaysia to have a qualified foreign lawyer, non-Malaysian. Okay, and we have currently we have 23 trainee solicitors. So sometimes we did not respond to any resume that were being sent to us simply because we are full. And now we have 23 pupils for now. Okay, if we can move to the next slide. So these are our practice areas. There are about 37, and I'm involved in at least 12 of it, which I will explain later. Okay, please tell me if I'm going too fast. I think I still need to finish by 3:30, right? Okay, the next slide. Okay, so this is very cliche, oftenly used, oftenly quoted. To be or not to be, there is the question. In this case, in this scenario, the process of being a lawyer. So I'm going to confine myself to 3 questions only. When, why, and how. Okay, when I had discussion with Dr. Hatini, we agreed that for this first session, we are going to tone down on the legal issues, and we are going to talk much about the purported success story of myself. So, under this heading, I will talk about the process of me becoming a lawyer. Hopefully, it will inspire my learned audience. Okay, the first question is when? When did I realize that I wanted to become a lawyer? Okay, it was in my primary years, in the early 80s. Maybe I was in standard 4 or 5. But why? Was it to uphold justice? No. Was it because I was so passionate about the law? But definitely not at that stage. Well, what inspired me was two distinguished gentlemen who were related to me by looking at their lifestyles. Okay, from my father's side, of course, there was Almarhum Sultan Azlan, but I have never met Tuanku except for one time when I was small. When there was one occasion, I was with my grandfather. But it's just the story that were the stories that were being told to me, you know, from when Almarhum Tuanku was the Raja Muda of Perak. No, when almarhum Tuanku was the Lord President, almarhum Tuanku was installed as the Raja Muda of Perak. And when almarhum Tuanku was still serving as Lord President, almarhum Tuanku was installed to the Perak throne. So that's from my father's side. But I am most inspired from my mother's side. From my mother's side, there was a person named Allahyarham Tan Sri Datuk Haji Muhammad Azmi Muhammad Kamaruddin, a Supreme Court judge and a Federal Court judge. So Allahyarham Tan Sri was quite close to my family. Whenever he came to Kuala Kangsar for MCKK All Boys Weekend, he would drop by the house, and I was inspired to see a black tinted Mercedes-Benz with the emblem Hakim Mahkamah Persekutuan. So actually that was the first idea. I was inspired by the lifestyle, of this particular person. And whenever that I went to his house in Kuala Lumpur, he would wake up at 4 a.m. writing judgment and whatnot. And almarhum Sultan Azlan, Tuanku was the youngest judge of the High Court, being elevated at the age of 33. Whilst Allahyarham Tan Sri Azmi Kamaruddin was elevated at the age of 35 or 36. So both were young, and both were about the same. So because of that, I told myself I wanted to be a judge. I wanted to be a judge. Now comes the question, how? How did I eventually become a lawyer? Okay, I had to endure a very long and winding road. After I completed my STPM, I think the results were quite okay. There were a few A's, but that was the first time where the Ministry of Education introduced the UPU form. So there were 5 columns. So you have to fill in column number 1, column number 2, all with your choices of courses and universities that you wish to go. I was confident enough. Probably out of ignorance, I fill in only the first LLB honors, UIA. So after a month, 2 months, nothing happened. So I had no choice. I enrolled into Form 6. Then I spent 2 years doing my 6th form. And then the STPM results were not quite good. There was no A, and there were other alphabets. So I purchased the form. At that time, I do not know now. At that time, you have to purchase, have to pay and purchase a form. Then they will send you the form. Then you will look at the relevant criteria of becoming a law student. And I did not fit into that criteria. So I wasn't a legal material, or a lawyer material, even to study law. at that time. But I was telling myself, what the hell, just apply. You never know. So I applied for the first time. UiTM call, set for a written test, attend interview. After 1 month, nothing. And then, so 6 months wasted. The next 6 months, I applied again to UiTM. UiTM called me again. Attended interview, set for the written test, and nothing happened for the second time. So 1 year gone. And then I was telling myself, what am I going to do? At that time, it was already 1 year after my STPM results. So I was telling myself that I had to lower my standard and apply to some other diploma in something from UiTM. And I got in. So I did this diploma. Unfortunately, for only 6 months. Because at that time, I was damn craving to become a lawyer. So I do not know what to do. Am I supposed to continue with this diploma in something? Then I contacted UiTM. I went to the office. They told me that lateral conversion is okay. But your result is like this. And this is your diploma in something. But if you want to apply for law, you can change. But law is like this. So I don't know what to do. And my interest was definitely not in that area. So what I did was I pulled out from diploma in something, UiTM. I was in UiTM Malacca at that time. So I pulled myself out, which led to the situation where my father and I were not in talking terms for about 3 months. But who can blame? Who can really blame my dad? I wasted 1 year trying to become a law student. Nothing. I was given the opportunity by ITM to do this diploma, and I walked away from it. So I do not know what to do. I applied to UiTM again for the third time, mind you. But this time, we had given you a place in diploma in something, but you rejected, you withdrew from the course. We are not going to entertain you. If at all, we are going to entertain you, maybe 1 year from the time that you left that diploma. Why? Because at that time, my name would no longer be in the system. So when that happened, I told myself, I give it another try. Otherwise, I leave it to God. What will happen to me? So for the fourth time, I had about 6 to 8 months to prepare. I bought a book, a small book. The title is Learning the Law by Professor Glenville Williams. So I bought the book and I read. And I applied to UiTM. I was again called for the test and the interview. And I remember the lecturers who interviewed me were Puan Su Valkis and Encik Helmi. And they asked me, this isn't your first time applying, right? I said, no. So why not? Why must you still apply? We will look at your STPM results. Look at our requirements here. We have some other better students, but I told them, this is I won't bother UiTM. I won't bother the law school anymore after this. But please ask me legal question. So they started asking me at that time, what is the meaning of prima facie? What's the meaning of beyond reasonable doubt? Some other Latin terms, all the concept of law. And of course, I remember after reading all the. And finally, I was let into the law school at the age of 23. 3 years after my STPM. And I was 3 years older than my batchmates. Okay, I think Dr. Habibah binti Omar was my batch, but of course, both of us, we were DLs most of the semester. Dr. Habibah was Dean's List, I was Dean's Laws. But regardless, I was happy because I got in. I was admitted to the law school, and the ambitions of being a lawyer is just few steps away. So there I was, being a student. When I got the first, of course, I had to undergo pre-diploma. At that time, it was ITM. I had to go pre-diploma in law for 6 months, and then diploma in law for 3 years, and then advanced diploma in another 1 year. But of course, when I was in final year of diploma in law, ITM was converted into university, and the program was converted into LLB and LLB honors. So I am thankful of being there, of being accepted into ITM. I'm thankful to Cik Helmi, and of course my best friend Puan Su Valkis. She was the course tutor at that time, and Cik Yunus and Puan Saudah Jan Lelo. Puan Saudah ni dia garang sikit ni, Kalau masuk kelas dia ni, sometimes tengah hari pukul 2 kan, mengantuk lepas makan, we have to pinch ourselves to make sure that we stay awake, Otherwise, she'll be asking us questions that we cannot answer, and then okay. But berkat doa all the lecturers that taught me, Alhamdulillah, I am where I am today. Well, not that high, but at least for now I'm rather comfortable. So that was the time when I got my first results, part 1 punya results. I opened the envelope. I was screaming with joy, and my father was asking me, "Oh, dapat 3-pointer ke? Dapat Dean's List ke?" I kata, "No, it's 2.74, and 1 paper fail. Constitutional law, I failed constitutional law." And why are you so happy? So happy because I get to go to part 2. I do not have to stay in part 1 together with my junior, Although I have to repeat my constitutional law paper with my junior, but at least I can still be with my batchmate. And the only paper that I failed, constitutional law, that becomes my forte now. I've been going in and out of federal court, Court of Appeal, High Court, arguing on constitutional issues which involve national interest. Okay, so after that, I had to go to at that time in order for you to have a direct intake into advanced diploma, or they change it to LLB honors, and you have to obtain 2.9, I think, at part 5. But I didn't. I was about 2.8 something. I studied hard when I was in part 6. I got about 3.19, I think, or something like that, with the hope that I can go straight to save the time. I can straight be admitted into the other program, the LLB honors program. But still, that was the rule. I had to work for 6 months. But of course, I was happy because most of my batchmates, most of my gang, they were together with me when we later joined the LLB honors program. So that was the story on how I became a lawyer. It may not be interesting, but to me, that is rezeki lah. First time rejected, second time rejected, third time pergi kelas lain, fourth time your name is still in ITM registry, and fourth time of applying to law school, then only I managed. So you guys should be thankful if you encounter some hardship in your law studies. There is nothing, because definitely it will be rewarded. You work hard and you will be rewarded. Okay, and can we please go to the next slide? We started quite late just now, so I still have to finish at 30.
Dato, we can extend the time.
MC? Okay, you just give me the cue, eh? Okay. So this is my lawyering experience. Okay. When I finished from LLB honors, so I was applying for a place to do my pupillage. And at that time, my mother-in-law, who was at that time my mother, so she was telling me, you go to Zaid Ibrahim and Co. for your pupillage. That's good. So I told her, okay. Then I went to the law school. I borrowed from one of the lecturers. And then I was scrolling down all the names of the firms. Then I found it. Then I called the legal firm. I wanted to send resume and to attend interview. And the firm kata, no, you come terus datang and you can start right away. I kata, wah, this my mother-in-law punya firm yang I under the impression that something Ibrahim and Co ni kata senang betul nak masuk ni. It was very easy, in fact. So I attended and I started. And then after a week after that, I met my future mother-in-law, and he was telling me, so how's everything? I kata, okay. So how much they are paying you? I kata, about X figure. Oh, that's low lah. That is not Zaid Ibrahim standard. I was asking her, excuse me, sorry? No, that was not Zaid Ibrahim's figure. And I thought, my goodness, I went to Zaid Ibrahim and Co, not Zaid Ibrahim and Co. You know, when I was scrolling down, S come first, then only Zaid Ibrahim. So I ended up doing my pupillage at Zaid Ibrahim and Co, and not at Zaid Ibrahim and Co, and not at Zaid Ibrahim and Co. But that's the hikmah there. From there, I was introduced to Dato Azmi, and the rest, as they say, is history. The first 6 months in Azmi Associate, actually, when I completed my pupillage, I was retained at that firm, and then we thought that we could do it. Then the three of us, my friends, one from ITM, another from UIA, we opened up our own law firm, and then we couldn't do it. We had to merge with another law firm, and we couldn't do it. Cannot even pay Kembara, despite I was using Kembara at that time. You know, despite being a partner in my legal firm, you know. So I cannot send it anymore. And then somebody introduced me to Dato Azmi, and then it was quite fast. The first 6 months was the most challenging time in Azmi Associate. At that time, the litigation department had just been established, so there were times that few of us didn't go back for 48 hours doing some Mareva injunction to be filed in Ipoh. But that hard work pays for more rewards. After 8 months, I was elevated to Senior Associate 2, and then less than a year, I was elevated as Senior Associate 1, and then about a year, Senior Associate as a partner. So I wanted to tell, I told myself at the time that I have lost 3 years of my time doing nothing, literally. So I have to catch up. So, Alhamdulillah, here I am. And if I look back, so things happen for a reason. If I got admitted in the first time around, maybe I won't be meeting Dato Azmi. You know, so for you guys, things happen for a reason. So just embrace it. Okay, can we go to the next slide? Okay, I saw some question. Maybe later you can pop up again. You know, you have to bear with me. I am a person who is without Instagram, without Twitter, without Facebook, without LinkedIn, and Alhamdulillah, I'm not living in a cave. Okay, now what is civil litigation? So, I think Part 7 and Part 8 students are well aware of this. I'm gonna cut short. I think you can read it for yourself. If you have any question, you can ask. But the point is, civil law defines the relation between people. When one party is being injured or harmful is done against him, then he is entitled to sue the other party. Okay. Okay. Next slide. Okay, this is because it is because what is the purpose of becoming a litigation lawyer if you do not know the origin? You know, so this is something for you just to, you know, to have in mind, for you to tell your non-lawyers friend, you know. The history, the origin of legal profession can be traced back to the ancient Greece and Rome. At that time, there were no lawyers, but lawyers at that time were regarded as someone from lawyers at that time were the orators of ancient Athens. So at that time, what happened was that there was no law. So every individual has to plead their own case, must plead their own case. But then, at certain stage, there was a growing tendency that this person tend to seek the assistance of an orator or their friend. So because of that, the rule that an individual must plead their own case was bypassed. But of course, at that time, there was no such thing as legal professional, and the orators could not charge legal fees. So not until during the time of Emperor Claudius, the legal profession was regularized at that time, and Roman advocates could charge their legal fees. But of course, Roman advocates were not legally trained. Neither were the judges. You know, they argue based on rhetoric. You know, all the rhetoric, how they use. Of course, we have the great, like Aristotle and the likes. So at that time, they could charge their legal fees, and the legal profession has been legalized. And during the era of the Byzantine Empire, there were rules limiting to certain numbers of people that could be admitted as an advocate at that time. And at that time, since there was no law, so everybody argued on rhetoric based on the practice and value of the Rome community during that time. In other words, it all came back to common sense. If A borrowed money from B, B couldn't pay, A is entitled to ask for the payment. Okay, the next slide, please. Okay. I am not selling litigation. I am just advising the difference between litigation lawyers and non-litigation lawyers. Okay, for litigation lawyers must be well equipped in both procedural and substantive law. You know, so as compared to other practice areas, assuming conveyancing, if you are doing conveyancing, that means you have to really understand land law, really have to understand all the relevant steps, and always take note of the changes in law relating to conveyancing. The same thing applies to corporate. That means you do not have to study other matters, which I'm going to deal with after this. So if you talk about litigation lawyers, you have to learn about procedural rules. Non-litigation lawyers, there is no need to study some other topics. Okay, next slide, please. Okay, you can read for yourself. These are the topics that are relevant to civil litigation. But there are also other topics which I didn't include. For example, like equity and trust. You know, equity is something very important. You know, most of the time we plead equity in our statement of claim or our defense. You know, equity and the like of those who comes to court must come with clean hand. something like that. Okay, next page. Okay, why civil litigation? Number one, it covers most areas of law. Okay, now litigation is quite. Of course, there will be other speakers. I'm sure after this who will be talking about corporate or IP law. But I have to say that litigation is the toughest, whether you are up for the challenge or not. Why? Because if you are doing litigation, you have to master the rules, the procedural, as what Cik Yunus taught me. This is the time where you really have to focus on the procedure rules. Of course, you have to cover, you have to be well equipped with other substantive law, because first is procedure rules, and then second is evidence. Okay, if you ask me, these two are core subjects that you really have to understand in law school. You really have to master these two subjects. Okay, other substantive law, land law, contract law, family law, those are very relevant. Of course, you have to score. You cannot be, otherwise who are you going to ask? You have to learn that one. But based on my experience, when I started my chambering, procedural rules and evidence law, I dealt with it almost on a daily basis. Substantive law, it changed from one case to another. This case involved land law. This case involved company law. This case involved medical negligence. So I hasten to add that I am not saying, and neither should I be quoted as saying, that those two subjects are the two most important subjects. No. But those two subjects, you have to really learn by heart, cover to cover when you have the time. You really have to whenever you're free time, just run through the rules. You don't have to really understand. Of course, the lecturer will teach you all the relevant subjects. But what I'm trying to say is that if you ask me a legal question on land law, I may need to ponder upon it, or I may need my chambering student or my associates to, can you please check this point of law? But when it comes to civil procedure, most of the time we have to, be able to answer almost immediately. So let's for litigators, would-be litigators, let's treat these two as combined first among equals. Okay, so that's number one. Okay, number two, new dimension, outlook, perspective, or context. Okay, I would liken the litigation area or cases as reading a mystery novel. Why? Because every time it involves different matters. It involves medical negligence, it involves constitutional issues, it may involve simple running down matters or accident matter, it may involve corporate dispute, with the exception of probably banking, because of my experience doing banking, most of the time it's standard, unless it touches upon complicated issues and running down matters. Even running down matters also, they are quite complicated also. You have to really understand because the nature of accidents are different from one and another, and you can get good money as well. Okay, number 3, transferable career. Okay. What I'm trying to say here is that when I was in LLB honors, the first, if I'm not mistaken, if not the first, probably the first Malay female lawyer, Puan Hendun Haji Muhammad, she taught me ethics. So she told me, or rather I was not sure because I was quite close to her as well. Either she told the whole class or she told me, but the fact is, what she told is that you have to do civil litigation first. Then it's easy for you to branch out to some other areas of law, which is true. Because in my capacity as a litigation lawyer, when it involves corporate dispute, I'll be reading the corporate agreement from cover to cover. If it involves a breach of contract, I would read the contract from cover to cover, you know, and what I want to say. Okay, so what I'm trying to say here is that if you do civil litigation and you want to transfer or you want to change your portfolio into a corporate lawyer, you will be, the corporate lawyers may disagree with me, but I think it will take probably 2 or 3 months for you to slowly rise up in the corporate world, you know. Whereas if you are doing corporate litigation and then you want to do if you are doing corporate and then you want to branch out to become a litigation lawyer, I don't think so. It may take years because you have forgotten all your rules, you know. There is, you know, in practice we have 7 days deadline, 14 days deadline. You have to file within 7 days, within 14 days, within 1 month. Sometimes there are not enough times for you to even look, you know. You must really know, you must really learn, you know. Everything must be, you must be able to just snap and get the answer on civil procedure, you know. And because of that, coming back, so if assuming that I wanted to become a litigation, I wanted to become a corporate lawyer, I've read many agreements before, because when it involves dispute, I have to read the agreements one by one, which does not only cover the dispute related, the clauses relating to dispute, but also from the very beginning. So it's all inside here. Then you know already. If it is sales and purchase agreement, these are the terms, you know. So so in my 20 years of experience, I had the opportunity of doing about not that many, 6 to 7 agreements, you know, because the client wanted me to do it. So it wasn't that difficult. After all, we have I do not know, either Atkins court form and precedent or Hasbury forms and precedent. You know, they have all sort of agreements there. So you have to look at the agreements, then you have to adjust and put in the relevant clauses. You cannot, of course, you cannot take it in bulk, all those clauses. You have to really adjust. So what Puan Hendon told me is, you better do litigation first, and then if you want to change to other area of law, shouldn't be a problem. Okay, number 4, it survives economic downturns. When the economy is booming, we are riding high, and when the economy is doing bad, we are riding higher. Hopefully, inshallah. I think I have quite good number of new assignments after this COVID-19, because people tend to unfortunately not being able to perform their part of the bargain, you know. course, we have to protect our clients' interest as well on the issues. Okay, number 5, rewarding. So litigation is rewarding. I as a matter of practice or rule, I do not take individual clients. Why? Because I rather do cooperation. The fees are secured. You know, the fees are secured. Because there was one time when I was on my own, I was defending. There was this bank who was suing my client, and I was defending him, although he was indebted to the bank. And I asked for my legal fees, and he told me, Encik, kalau saya ada duit, dah tentulah saya bayar bank. Tak adalah saya nak bayar dekat Encik. You know, macam ni punya orang pun ada juga. But you have you have been appointed to represent him, but you just have to continue. Of course, you can file a notice of discontinuance. So if you represent, because if corporate, it's certain. What do you want to do? I'm going to do a merger and acquisition of company A. What will be the fee? X figure. But litigation, you file summons or you file defense. Then the other party will file application to strike out. You file defense, there's a fee there. Then the party will file another application to strike out, then another fee there. And then we file, the claim was not complete. We file an application for further and better particulars. There's a fee there. You know, it's uncertain but rewarding. It's uncertain but rewarding. You know, like lawyers used to charge millions. You know, millions they used to charge. I have yet to reach. I think the highest legal fees that I have ever charged is 1.4 million in one matter, and that amount of fee came only once in my 20 years. You know, but of course throughout the years I have good fees lah. You know, sometimes few 100,000. So to me, litigation is rewarding. And number 6, it is exciting, not bored. You know, because you get to travel. You know, you are not stuck in the office doing the same things. You travel to this court, you travel to that court. When I was doing my 6 months of attachment before I was admitted to the LLB program, you know, I went to Kedah, I went to courts in Perak because my supervisor at that time, he was doing running down. So, you know, discovering new places, discovering new foods, you know. So that is very exciting. And you are this time you are doing this time you are doing that. You know, I have been doing few national interest cases pro bono. I can easily charge maybe 200,000-300,000 on one matter. I did it pro bono because it was close to my heart. You know, on constitutional issues. You know, because it's interesting. It's interesting. You want to be part of the person who shaped the law. So as a civil litigator, you must have that feeling inside you. I'm not going to just do this matter, you know. I'm going to do something. I want my name to be recorded in the law journal, you know. Once I'm 6 feet down under, gone and dead and gone, you know, my generation can still look, you know, if you, you know, the next generation of students can still, relying on this case. You know, this case is good. So that must be your aim. Okay, number 7, meeting new and interesting characters. Okay, meeting new and interesting characters because you will meet all sorts of judges, all sorts of all people. You really you will really make friends with all this with civil litigation, and you meet your clients. You know, this person of things, and then you were able to play a bit of Game of Thrones here and there, and we were involved in certain matters, because I think 1/3 of my resume, 1/3 of my working experience, I cannot disclose, either because it falls under the OSA, or under the NDA, or simply because that person or some persons, they are, just VIP. So we have to really protect their interests, Okay, next, number 8 is prestige. So this is the oldest profession in the world. I replace, this is the oldest noble profession in the world. So during the early times, to me, there was nothing about this, nothing about that. The only thing is, you have to go to court. What are you doing? You are a lawyer. Oh, you go to court? No, I sit in the office. So personally, I cannot have that in mind lah, because that is my nature. Okay. Number 9, opportunity to practice other areas of law. Okay, if you are a one-man show, I maybe if there is rezeki some other time, I was invited to give talk to the small law firms convention organized by the Bar Council, and then I was called by the State Bar Committee to share about this firm, to distinguish whether you want to be in a big firm or you want to open up your own small firm. If there is opportunity, if this is a successful, I got marked at least 51%, then we can have the second talk specifically on that, because some issues are not taught in law school. Some are just not taught in law school because you have enough subject in law school. Okay. Okay, I'm coming back to number 9 just now. Sorry, number 7. Okay. Those time during my early, the first time I appeared, not to say I appeared lah, when Justice Gopal Sriram was elevated to the Court of Appeal, directly from practicing to Court of Appeal, he was one of the well-respected judges, and some of the lawyers are afraid of him. So there was one time that when I was doing my pupillage, the lawyer quit, and there was only my master who was doing corporate and conveyancing. So I had to go to the Court of Appeal to advise Justice Gopal Sriram, who was presiding the quorum, that I do not have lawyer to come. And I went and met the interpreter, and I told her my predicament, and he was like, "Yeah, you are a chambering student. You are a chambering student. You cannot be heard. And then I lucky I met my opponent at that time. I think it was from Sien Telemo, I think. So I explained my predicament. So he was kind enough to tell me that he will advise the court. And so I was sitting at the back lah. And then he was explaining the situation. And then Justice Gopal was like, where is the chambering student? Where is the chambering student? So what do you have to say to the court? So I was addressing the bench from outside from the public gallery, So that was one. That's what I said. This is adrenaline rush you are doing. There was this time. There was one judge. The moment you enter the room, he was like, "What nonsense are you filing right now? How do you think you can succeed this sort of application?" The whole of the courtroom. Of course, you enter into the courtroom, could hear him scolding you. I was like, but true enough, the application was about 50-50, because what happened was that my client was made a bankrupt. He was a VIP, so he wanted to wrangle through lah. So we found few technical error here and there, and we've appealed to the judge in chambers against the bankruptcy order. But of course, it was thrown out lah. But what I'm trying to say is that it really bring your character, it enhance your character, being able to appear before all sort of judges, to argue before all sort of judges, you know, and to, you know, kena marah ke, kenapa ke, well, that's part of life. That's part of life. When I, you know, bila you buat your privilege, when I was doing my privilege, I had to file borang 1 and borang 2, I think part 7 and part 8, you should know about this. And then form 3, 4, 5 was for the short call. And then my mistake was that bila buat conveyancing kat ITM, bila belajar conveyancing kan, asyik duk copy paste saja kan, bukan nak buat betul-betul pun copy paste. So dia terbawa-bawa kepada when you were as a pupil. So what I did was that I copy pasted the affidavit of service borang 1 and 2 into the affidavit of service of borang 3, 4 and 5. So definitely it's the different heading, because form 1 and 2 is your name as petitioner, but forms 3, 4 and 5 is the name of your master moving the court for you to be allowed to appear pursuant to the order 36. So that's because of that simple mistake, I was scolded by the judge in front of everybody. And I remember until now, and I try as much as possible not to repeat such a mistake. Okay, number 10 is just for the fun of it. At least I can say I have 10 reasons why you should become a civil litigation lawyer. Okay, next page, please. Okay, traits to become a successful lawyer. Okay, number 1, communication skills. You must be articulate. You must be your rhetoric side is also important. You know, engkau laksana bulan, pipi pau dilayang. You know that. Of course, you are not going to say that in your legal argument, but something like that. You need the judges to hear you. You know, judges to hear you. And the first crucial time, especially in appeals at the Federal Court and Court of Appeal, is the first 5 minutes. You really have to hammer your case the first 5 minutes. You know, I think I forgot. I forgot what our great Counsel Richard usually say. I think what is your killer point? What is your killer point? I think he said that. What is your key point or killer point? You know, what is your killer point? You know, because judges, they read already your submissions. They read already. Sometimes they need you to argue more on certain issues. So the first 5 minutes is very important. That's why your rhetoric must be good. You know, you have to be articulate. You have to be a good listener. Okay, number 2, assumption and presumption skills. Okay, most of the time, the dispute involves thousands of documents, but sometimes we just want to infer certain things which are not in the documents, which isn't being specifically addressed or stated in the documents, but you know that there is some missing link. So this is the position where you must have your assumption and presumption skill. You want to cross over your point. You know, when you were doing your mooting, I put it to you that you know he intended to breach the contract. You know, something like that. So there is assumption and presumption. You must know your case. You do not have your documents exactly saying that. Otherwise, you would have easily win the case. But because you do not have that, so you have to understand the assumption and presumption. You must know where to put. What is your case? That the documents, the facts that you are trying to convey to the other side, to the witness, It's not in the document. But if you look at document A, document B, document C, reading the three documents, you can infer something. So that is where that trait comes useful. Number 3, analytical and research skills. Of course, this is very important, especially the subject. Oh, I forgot. I think the subject of legal opinion. Legal opinion is very important. You know, legal opinions. Based on my experience, if I have 10 clients, maybe 4 would like legal opinions. 6 would just leave it to me and do whatever I want. This is the document. As far as we're concerned, we just want to win the case, hopefully. So that is very important. So you have to, from the very beginning, you have to assess your case. You have to understand your facts. You have to fully understand your facts. You have to tell your clients, please give us all your facts, because sometimes the clients, we held the relevant documents and the documents came from the other side and you got surprised. Okay, number 4, people skills. Okay, we lawyers, we work for the people and on behalf of the people, you know. And sometimes you really have to tell the client nicely, okay, this is the case, it was postponed because of this and this, or the delay was postponed, the trial was postponed because of this, or that we cannot proceed with the trial as yet because there was an application filed. No, because sometimes the clients, if they are being sued or they are suing, they are restless. You know, if you put yourself into their position, you are going to be restless too. No, so that's why the people skills is very important. And 5, perseverance. You know, you have to. If you look at my story just now, it is, they say it is not a sprint, but it is a marathon. But to me, it's a bit here and there. You know, in order for you to achieve at this level, it takes time. You know, when I first appeared at the Court of Appeal, I was preparing, and when I first appeared, I was asked questions I couldn't answer. I was like stunned for about 1 minute, literally stunned. You know, and I thought I had covered everything. You know, but unfortunately, no. Why? Because I was too nervous. So even up until now, I still have the nervous, because I asked 2 or 3 senior lawyers, and they said to me that it's normal. You must have that butterfly in the stomach feeling, because that shows that you are concerned about your case. Okay, number 6 is creativity. You have to really think out of the box, because if you look at certain positions, sometimes, okay, these are the standard position, these are the standard facts, 1, 2, 3, 4, 5. Okay, then you look at it first glance, you say, nothing can be done. But sometimes a lot to be done. You have to be able to read the fine line. You have to be able to read between the lines. You know, then you will be creative enough. Number 7, of course, patient. You have to be, you know, because imagine, like we are, I think we have hundreds of active files. You know, so your minds are juggling. So you have to be patient, because sometimes you are ready for you have prepared everything, and then the case got postponed. Now, and number 8, hard work. I don't have to talk much about hard work. Okay, next slide, please. Okay, Theodore Roosevelt best sum up this excerpt from his speech about the passion and satisfaction, which most of the authors in litigation will quote this. I think you can read it later. Okay, next. Okay. Because we are lawyers, and I am a lawyer, so it's okay that I'm saying this. Why? Because this was an excerpt script taken from the play Henry VI Henry IV, I think. Because what happened, there was a rebellion against the government. And the only person or profession between the rebels and the government were the lawyers. The lawyers were the ones who said that you cannot do this, you cannot do that, you have to follow this, you have to follow that. Hence came this quote by William Shakespeare. Of course, sometimes it can be very difficult, you cannot do this, you cannot do that, so sometimes our own clients also, please reverse. Okay, next page. Okay, this is my favorite quote by Soekarno. Bermimpilah setinggi langit. Jika engkau jatuh, engkau akan jatuh di antara. You have to think high. You have to dream high. You must, from now, when you are in part 6, you must tell yourself, never mind if it involves materials. From now, I'll be able to buy. You must be able to buy 5 Series or E-Class Mercedes. You really have to do that. And 10 years from now, I want reported judgment. And 10 years from now, I want to have a good, which is known to the legal profession. So you have to really dream. There's nothing wrong with dream, because there are 20,120 lawyers, not including guys. So you are going to do your privilege soon. If you maintain the normal speed, then you will be like any. You have to, only you will be able to feel the satisfaction in terms of career. Okay, in terms of study. Before I touch that, when I'm drafting papers, to tell myself that why completed drafting your course papers, you would only acquire about 60% to 70% only. Definitely, maybe to some great lawyers, but definitely you cannot achieve 100%. But you can achieve 100% or 90% or still got an A+ in your studies now, But when you come out later, because you cannot be aiming up. Never mind, I just do it 60% or 70%. That would be all right. Cannot. We are talking about balance of probabilities, okay? So this is balance of probabilities. This is the plaintiff, this is the defendant. So if you go for 100%, and then you realize that you only get 70%, the balance is still in your favor. You can still win the case, or worse come to worse, 51%, you still win the case. So achieve for the highest possible that you can do, Next slide. Okay, I think I have talked long enough, I would like to thank all the lecturers. I do not know who are the lecturers inside here. but I would like to thank for everything that you have taught me. Kan, benda-benda macam ni yang jadikan kita orang kata, okay. And I think Dr. Aiza was my chambering student, Dr. Aiza. So she had the benefit of learning under me, or rather, I had the benefit of learning from her. So I hope that this talk, this webinar, has been useful to the students. And if there is time, I am willing to answer any question posed. Thank you.
Thank you very much, Yang Mulia Dato'. That was quite a challenging path that Dato' has to gone through. But Alhamdulillah, Dato' was able to hurdle the challenge with your head up high and dignity. So we will open the webinar to question and answer. If you have any questions, you can ask the question on using the chat box. Okay, there are a lot of questions already here in the chat box. To go through, to allow everybody to ask questions here, I do think that some of the matter had been covered in your speech just now. So basically, just let me try to sum up a little bit of your speech just now. So you were encouraging students to start their legal practice to do civil litigation, because by knowing the procedure, you practically will know all the substantive law. And knowing civil procedure and being able to practice civil litigation, it would be easy for a practitioner to move to other branches of the practice. Isn't that so, Yang Mulia?
Yes, sure.
All right. So we will try to entertain the question, but this one I want to pick a question which is actually reflected the type of practice of some of the legal firm. There is a question here that asks, why does a small firm, especially handled by young lawyers, seems to fail at the beginning of their practice? Is it because of lack of marketing or lack of networking? Since Yang Mulia Dato' also had struggled at the earlier part of your practice, probably you can share some of the reason for the failure of small early legal firm. Yes.
Okay, I think based on my experience at that time, the most important thing was that when you were new, then people tend to be rather skeptical. Can you do this matter? Whether you can do it or you cannot do it. But the idea is, especially now, it's all about marketing. You have to market yourself. You have to market yourself. You have to equip yourself with the relevant knowledge. You have to meet the potential clients, and you have to show to the potential clients that this is your case. This is what I intend to do about it. So, but unfortunately, during my time, I was too naive, or I was being lackadaisical about on those issues, So I paid the price. And one other thing is, most of the times I am working with a small firm. If they have a big case, assuming that they receive a big assignment, sometimes they turn away. But don't. You just appoint a counsel. And then you discuss the fees with the counsel. How much? So at the end of the day, how you present yourself is important to the clients, because the clients are in a difficult position. They are in dire need of a lawyer who can defend their case or who can claim something. They are already distressed, so they need to see a person who is capable of handling their dispute, which you can do it even though you are a new lawyer. You know, just make sure you understand the facts and understand the law. And when you are confident enough, then people will go to you. Coupled with the fact that you can offer a good legal price compared to other established firms, they will go to you. Okay.
Okay. Does this mean that for the couple of years after you have been called to the bar, you should not be setting up a firm of your own? You would you should work with other people or with a firm to gain that knowledge, to gain that confidence, as well as to get that reputation. So, do you encourage a new lawyer to start immediately after being called to the bar to start their own firm?
Well, I had bad experience on that because when I opened up, there was no clients, and we were relying on our friends, our family members' friend to become the client. And at that time, there was no online legal LexisNexis, CLJ LawNet, and whatnot. So that was the restraint back then. So I have to, I do not have the opportunity. So at the time that it's better for me to go to a big firm to learn and then go back to a small firm. But I'm still stuck here lah. But nothing stopping you, the students, from opening up their own firms. You know, nothing stopping them.
It's good to dream, as what Yang Mulia said just now. It is good to dream. It is good to dream big, because by dreaming big, then you work hard to achieve whatever you dream. I have a question here by Muhammad. Assalamualaikum, Yang Mulia Dato' Raja. During your time as a student before, how do you keep your interest to learn law? Because speaking in perspective, as a student now, reading law, commonly known as difficult, course, and sometimes there seems to be no ending, as there will always be materials need to be attended. In other words, what inspired you to keep going when you study law before? Because now a student that does the Part 7 and Part 8 program at the LLB Honors, they don't call the program LLB anymore. They call it Hell B, because it is hell of a situation there. So what keeps you, what pushes you to continue when there are always new things to do? Tomorrow there's deadline. Okay, next week there's test. There's some more assignment. There are files to do. So what pushes you?
Okay, during my time, it was called LLB, lama-lama bodoh. So this is better still lah. Okay. When I was in Part 1, there were about 80 of us. And then when I was admitted into the honors program, there were only about 48 of us. And at that time, I do not know. We were under the impression that the lecturers were having their own strategy, you know, were having discussion to give assignment at the same time. So Mr. Rajesh would give something, Tuan Lee Chong Fok would give something, Mr. Dabi bagi something, lepas tu Puan Hamidah Masono akan bagi all the convincing, and everything must be completed within 48 hours. And not sleeping for 48 hours were normal for us at that time. Were normal for us. We just really have to juggle. We have to juggle. And we are not the like of Dr. Habibah, Bedi Omar. They study all the time. You know, we study and then pergi sini lah, pergi sana lah, tengok wayang apa lah. So, bila kita masuk honors tu, at that time, we were really hard pressed with time. You know, we have to learn everything back. We have to do everything back. And there were times that we didn't sleep for almost 48 hours. But that is nothing compared to being in practice. You are going to, especially during civil litigation, you will have a lot of A lot of things to do. Okay.
Quite a busy day.
No, I need to. Can you come, please? Alright. No, I need to show my timetable. That just to show that I think I enjoy it very much being a student rather than being a lawyer. But of course, being a lawyer is rewarding. Can you just show in a glance through 1 second for this? Okay. Just one second. Okay, these are all the cases that we have to make. Okay, dah. I cannot show too long because it involves the names of the clients. So,
Okay, yes.
But on the 12th, on the 13th, 14th, every day we have to meet deadlines. Every day we have to meet deadlines. I sleep every day at 3 a.m. and I woke up for subuh and then I start working. So, but that is the lifestyle that I want. Because I have certain mortgages to pay, I have to pay for my car. So I think that I need that luxury. So because of that, I have to work hard. I have to really work.
Yeah, that concern with the dream just now. You dream big.
Yeah.
Push you.
I said, and so far, alhamdulillah, I think last week I just last 2 weeks, 1 day, 2 days before Raya, I got a brand new car. So there is my satisfaction. So I dream high, but of course I have to pay for it with my time. Okay.
So dreaming, striving for it, and the obligation, the financial is actually the motivating factor to strive. Okay, I have a question here by Ahmad.
Before that, just one last point. For the student who asked just now, don't think about it now. Think about what will happen after your graduation.
All right.
Then
Okay.
you will be rewarded. Passing the subjects and be rewarded with law degree is, mashallah, is good enough.
Okay, that brings us to Ahmad Zulhazi's question. Dato, in handling civil cases, would you rather make a settlement with the opponent or would you prefer to go for a trial instead? So, choice between settling and fighting it in court.
Okay. If you go for settlement, you won't get that much fee. If you go to court and you litigate the matter, you will be rewarded with fees. But at the end of the day, you are protecting your clients. You are not protecting yourself. So most of the times, if there is a settlement, most of the lawyers will push for the settlement. Why? As long as the settlement benefits the client, or win-win situation, or 60-40 winning factor or whatever, so we have to go for the settlement. If the client is agreeable, if we protect the clients, if you go to court, you are going to pay 100,000 legal fees if we go for trial. But that is the price. But if you go for settlement, they are going to pay you 50,000. So the client must be able, with our help, to assess. If we go for trial, then we have to pay Raja 100,000. But now we got 50,000. And if Raja won the case, then he get cost of maybe 30,000. Then that's 130 already. Then we have to pay him 70 minus the cost awarded. This one is 70. So which one is better? So usually we will never forgo settlement. If we can settle to the best to our client, yes. Because rezeki ni banyak lagi datang. Trust me.
Yeah. Yeah. I suppose one has to wait which one of the choices actually benefit in the interest of the client. The most important thing is the client's interest must always be protected. If it is a settlement, then it is a win and win situation. Right.
Yes.
We have a question here by Ain Nur Afika Saiful. Assalamualaikum, Yang Mulia Datuk Raja. I have a question regarding fresh law graduates' employability. My question is, when law firms are looking for people in chamber or legal associate, what do they tend to focus on? Would it be mainly the CGPA or their soft skill abilities that they show during the interview? In addition, is there any other matters that law firm employer is looking for? So this is a student who are about to go to chamber. What does the law firm look at when they were looking for chamber student or they are looking for a lawyer or an LA?
Okay, talking from the experience of Azmi and Associates, I think most of the time, the general rule is that you must be at least 3-pointer. But for me, I will not only look at whether you are, others will, general rule, we have to look at the 3-pointers, then it will be filtered, it will be shortlisted, and will be given to the respective partners to evaluate. Okay, but I always tell my HR, even if a student gets 2.8 or 2.7, you give it to me, because I want to look whether they are active. Sometimes they are active. They are smart, but because they are active in this, they are active in Philip Jessup, or they are active in debate or whatever, sometimes it drags their CGPA. So we look into that as well. And number two, the second time, it's very seldom that I ask a legal question during my interview. The question that I ask them usually, or rather the HR will call them and ask that a litigation partner will be interviewing you. Number one, whether you are interested in litigation, and number two, whether you are willing to forgo your life to do litigation. Because my group, we work 7 days a week. 7 days a week. Why? Because this is meeting deadlines. Because we have so many deadlines. So if there is an opportunity for us to rest, we rest. Sometimes we take turns. But for me, when there are two teams, I have to juggle between both teams. I have to look at this team's work. I have to look at this team work. So even if you don't worry, because an additional factor, I always look at the SPM results. That is most important for me. Every candidate, I will ask for SPM results. I will look at their BM, I will look at their English, I will look at their mathematics. That is for me, because those are the three core subjects that I need, apart from their transcript.
So CGPA is important, soft skill is important, but most important is, are they willing to work hard and strive together with the employer or with the firm? Is that the point that Yang Mulia was making just now?
Yes, I wasn't a 3-pointer. I hit 3.919 just once in my in my study years, But yeah, I worked out, So I believe, if I need to be given the chance, so others should be given a chance.
That's unfair. So probably last question. There are a lot of questions still in the chat box. However, I suppose some of it was covered during the presentation just now. Time is so jealous upon us. I'm sure that we do not want to take Yang Mulia Datuk time anymore. So probably last question here by one of the students, but I cannot scroll down again. I do not know the name of the student. So, but the question goes like this: since most of us are final year students, can you share any tips for us when we start our pupillage? Can you share any tips for us when we start our pupillage? Yeah, probably that's the last question today.
Okay. That is a simple question, but takes easily half an hour to really go through one by one. But what important is that, as I told earlier, you have to know what you want to do from now. That's why the period of internship is very important. when you are doing your internship, you learn whatever you can learn. You learn litigation, you learn conveyancing, you learn corporate. Then you have maybe a year before your final, before you finally go for your pupillage, then you will be able to know which areas of law that I want to do. You know, so that is the very important person, and the very important things. And of course, you have to work hard also. You have to work hard. You know, we have 23 Chamberlain students. So we also sometimes when we want to confirm, we look at their you know, how many of them came during weekends to work. You know, how many of them give excuses when asked to come during weekends. You know, all that sort of thing. But when you do your pupillage, you must aim to be retained there. That's the most important thing. Don't, unless you just want to get called and you want to work at your father's firm or your mother's firm, which happen to many cases, you know, or you want to join some other sector, you know, you just want to get qualified and then you want to join the army, you know, because legal graduates are on very high demand. But the most important thing is you must try, you must achieve that so that at the end of the day, at the end of the pupillage period, you are being retained by the firm.
All right, thank you very much, Yang Mulia Dato. Thank you for sharing your experience and your tips to the law student. As I mentioned just now, there are still a lot of questions that the student would want to ask Yang Mulia, but we do not have time. I'm sorry, I have to cut short. But to give an opportunity to the Dekan, Professor Madya, Dr. Hartini Sarpan, to address our audience, Dato. Dipersilakan, Prof. Dr. Hartini. Prof, your microphone is in mute.
Sorry. Assalamualaikum warahmatullahi wabarakatuh. Thank you, Cik Yunus. Thank you, Adiba, WMC. And most of all, thank you, our guest of honor today, Yang Mulia Dato'. Thank you so much for your willingness to speak to our students, particularly, you know, to share your experience. And I think whatever Dato' has shared with all of us today, this is very valuable, something that you cannot get it within the four walls of the classroom. And that's the idea of having this session. When we had our discussion, I think early of this year, kan Dato', we want to have what we call a mentoring session with the captain of the industry, and this is the very first session specifically on civil litigation. And I believe that many more sessions with Dato' will come after this. And for that, thank you so much, Dato', for your willingness to be part of this program. And for your information, my dear students, Dato' has given his commitment to be with all of you, and this is just the beginning, and we will have more mentoring sessions after this. And I think Dato's talk has opened our eyes, and this is a very good eye-opener for all of you, my dear students, to believe in yourself and to tell yourself that you can actually go through this difficult time, especially during, you know, this pandemic. Everything is very uncertain, but when we listen to Dato' just now, I hope that will inspire and motivate you to be to graduate and to soar really high out there. Remember what Datuk said, mimpilah setinggi-tingginya, because kalau kita mimpi di tahap yang paling tinggi, kalau kita jatuh, kita akan jatuh di antara bintang-bintang. That was really great. Datuk, thank you so much. This is the evidence of your philanthropic action, and I really hope, my dear students, this is going to be a very good example to all of you. Tidak kira di mana-mana dan sejauh mana kita kita mendapat pengiktirafan dan pencapaian, kita tidak lupa kepada our own alma mater. And Datuk, congratulations on all your achievements so far. And we are very proud alma mater, and I think this is the proudest moment for us, and thank you so much. And thank you to all for joining us. Thank you to my dear students. Thank you to lecturers. Thank you for your time, and we hope that this is going to be a very good beginning, and we're going to have more sessions after this. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Dean. Please,
Datuk.
kita ada sesi bergambar lepas ni. I shall pass now to the to continue with the program.
I think Datuk, you want to say something?
Just one thing, Cik Yunus. Thank you for the participants. Thank you to Prof. Hatini, Cik Yunus, and the MC. And one last thing is, for those who have not have the opportunity of answering your question, I think at the slides there, the last slide, there is my email address. So feel free to write your question there. But give me time to answer.
Yeah.
Okay. Thank you very much, Dato'.
Okay, thank you.
MC, the floor is yours.
All right, thank you very much, Yang Mulia Dato'. It was indeed a very informative sharing session. I'm sure it had inspired the students to view litigation as a future career. So looks like our event today has come to an end. Before we do end the session, I would like to invite everyone to switch on their video function for us all to get a group photo. All right, okay. All right. Okay, everyone ready?
Ready.
Okay, smile. 1, 2, 3. Okay, can we get another one? Okay, smile. 1, 2, 3. All right. Okay, thank you for joining us today. I hope everyone had a pleasant would have a pleasant day ahead. Assalamualaikum.
Assalamualaikum.
Everybody.
Okay, bye.
Okay, thank you, Datuk. Thank you, everyone.
Thank you.
All the best.
Okay.
Yeah, thank you, Dato'.
Thank you, Dato'.
Dear students and participants, dear students and participants, don't forget to register at the link given at the chat box for certificate purposes.
Terima kasih. Bye.
Thank you, Dato'.
Thank you.
Thank you so much.